Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis.
In addition to the market value of the land as provided above, the prescribed authority shall award a sum of 15% on such market value in every case. It should be solatium in consideration of the compulsory nature of the acquisition. Similarly, in the Harijan Welfare Act, when the amount is determined, there is no offer made and therefore it does not become an award. When the authority tenders payment of amount to the persons entitled, it becomes an award. Until such a tender is made under Section 11 of the Harijan Welfare Act as held by this court in the above cited judgment, in the eyes of the law, there is no award of compensation at all. If any tender made under Section 11 of the Harijan Welfare Act is challenged, it may be that an award of compensation is under challenge. But under Section 9 of the Harijan Welfare Act, it is only the amount determined which is challenged by way of appeal and not an award. To apply Section 51 of the Court Fees Act, it should be satisfied that the appeal is against an order relating to compensation. It has got no application in this case. It is neither an order nor an award under Section 51 of the Court Fees Act. Similar view has been taken by the court in the above cited case also. The learned counsel for the petitioner has placed reliance on the judgment where the Honorable Supreme Court had an occasion to deal with Section 18 of the Land Acquisition Act 1894 and also declared that the said reference can be constituted as an award or not. Honorable Supreme Court has answered the same in the negative and relevant findings are extracted in the judgment. Reference under Section 18 is not an appeal against the award and the court cannot take into account the material relied upon by land acquisition officer in his award unless the same material is produced and proved before the court. Award of land acquisition officer is not to be treated as judgment of the trial court. It is merely an offer and it cannot be utilized by the court unless produced and proved before it. It is not the function of the court to sit in appeal against the award and to approve or disapprove its reasoning or correct its error or affirm it or modify it or reverse the conclusion reached by the land acquisition officer. Court has to treat the reference as an original proceeding before it and determine the market value afresh on the basis of the material produced before it. Of course, the material placed and proved by the other side can also be taken into account for this purpose. The claimant must produce material in support of his claim and for the enhancement of compensation. Reference should be dealt with by the court. A close reading of the last paragraph of the above cited judgment would show that the claimant is required to establish his case. Ultimately, the court only decides the amount.